Okay, we will go ahead. It is nice to see you. I am Andrea Lefebvre, Director of Education and Compliance at UBA. Today we have an amazing presentation given by two attorneys from Kutak Rock. We have Brian Bartles and John Westerhouse. You may be familiar with the name Kutak Rock as they provide some compliance resources at UBA. And the topic for today is creating and maintaining a compliant wellness program, something that we can all use a reminder on, as there are some pretty in-depth and complex rules surrounding that. I'm going to turn it over to Brian and John. Oh, and as a reminder, if you can please put your questions in the chat, and they will all be addressed at the end of the presentation. Brian and John, I turn it over to you.
Thanks. Good morning, everyone. My name is Brian Bartels. I'm an attorney with Kutak Rock. I'm a partner in our Omaha office. For those of you who aren't as familiar with Kutak Rock, we have 19 offices across the United States and somewhere between 500 and 600 attorneys located all across our platform. So we're very excited to be part of UBA and present today. My practice focuses on health and welfare plans. I spend a lot of time negotiating administrative services agreements and then HIPAA business associate agreements, assisting clients with HIPAA compliance for their self-insured group health plans, and then advising on just day-to-day operational issues that come along on everything health and welfare plan related. With that, I'll turn it over to John to introduce himself.
Hi, everyone. My name is John Westerhouse. I'm an associate in the Omaha office, and my practice is not limited to health and welfare programs, but is more tailored toward union benefit plans, both the retirement and the welfare and health benefits that are offered by those plans. I've been working in that field for 7 or 8 years and happy to be with Kutak because of the wide variety of questions we get asked.
With that, I think we'll jump in, and just one other reminder, through your UBA partnership, you have access to the UBA compliance desk. And so when you send an email to the compliance desk, depending on what the question is, either John or myself or some of our other colleagues will respond to it. So it's a great resource. Just a friendly reminder that that's available for you. And we enjoy it when we hear those questions from everyone. So with that, we'll jump in to our presentation. So before we begin, we want to just give a brief agenda of where we're going to be going today. We're going to first talk about wellness programs, the background, primarily focused on HIPAA, the Americans with Disabilities Act, or the ADA, and then the Genetic Information Non-Discrimination Act, which is also referred to as GINA. We'll briefly touch on litigation that has happened in the wellness program space and how that has affected and created quite a bit of compliance challenges. And we'll discuss common plan design issues that we see, common compliance issues we work with clients to resolve, and then kind of some best practices or steps that employers can take to make sure that their wellness programs are being operated in a compliant manner.
Oops. So as Brian mentioned, there are 3 sort of big areas of law that affect wellness programs: HIPAA, the Health Insurance Portability and Accountability Act, the Americans with Disabilities Act, the ADA, and the Genetic Information Non-Discrimination Act, GINA. But those are not the only laws that affect wellness programs. They are the 3 that we're going to spend the most time talking about today. But there are lots of other overlapping laws that can affect wellness program design and compliance, including ERISA and the Affordable Care Act, because it's usually tied to a healthcare program, the Fair Labor Standards Act, because there are employment law overlaps with wellness programs and requirements, and the Internal Revenue Code, because there are often tax issues that arise with wellness programs as well. And even though there is preemption of a lot of these rules in federal law, so it's usually federal law that applies, there are instances where state and local laws can also affect compliance. So maybe the major takeaway from here is that there is a lot to consider when designing a welfare plan, wellness plan. With that, I'll turn it back over to Brian to give us a bigger overview of wellness programs.
Sure. So our starting point when we look at wellness programs is HIPAA. The HIPAA regulations for wellness programs were released in 2013, and they create an exception to the general rule under HIPAA that a group health plan cannot discriminate against a person based on a health factor. So the wellness regulations provide a mechanism for an employer to provide, either reward or penalty, depending on, what terminology you want to use and how you want to look at it, for activities related to a health factor. So whenever we're thinking about how we're going to comply or design a wellness program, our starting point is typically the HIPAA regulations on wellness programs. The HIPAA divides wellness programs into two broad categories: participatory wellness programs, and then health contingent wellness programs. And then health contingent wellness programs are broken down into two subcategories: activity-only wellness programs and outcome-based programs. And it's important to know where we're at in how we're classifying the different wellness programs, because the compliance obligations vary depending on which part of our Choose Your Own Adventure program we're at here. So as John is going to talk about in a little bit, participatory wellness programs have their own set of requirements, whereas activity-only and outcome-based programs have a different set of requirements. So it's really important at the onset that we understand what the program design is going to look like, or what we want it to look like, so then we can start working our way through this path to determine what set of rules are going to apply as we design the program. John?
So a participatory wellness program is maybe the simplest type of wellness program, because it's a program that either doesn't provide a reward at all, or the reward that is granted isn't based on a healthcare factor standard. So basically, the names of these programs tell you a lot about what they are. This is a program that rewards participation, right? And the HIPAA requirements for these are simpler than for the other types of wellness programs, the health contingent ones, because there isn't a reward limitation as there are with those types of programs. And the major requirement is that a participatory wellness program needs to be made available to all similarly situated individuals, regardless of health status. Now, oftentimes when you see legal words like similarly situated, it's hard to understand what those are. But in this case, HIPAA does define what similarly situated individual is, and they state that it's a grouping based on a bona fide employment-based classification that is consistent with the employer's usual business practice. And basically what that means is you could have a different wellness program for part-time workers versus full-time, or things of that sort. But as long as you divide people like that into those classifications, the participatory wellness program has to be made available to everyone in that classification. And an example of a participatory wellness program, there are lots of these, so we gave a couple examples here, but a program that rewards employees for attending a monthly health education seminar at no cost, or a program that provides rewards to employees who complete a health risk assessment, but doesn't actually require they take any action after the assessment, that simply completing the assessment is enough, or a program that rewards employees for attending a smoking cessation seminar to quit smoking, but the reward isn't actually predicated on whether or not the employees actually stop smoking or not, or a program that reimburses the cost of a fitness center membership. And it is very easy to turn a participatory wellness program inadvertently into an activity-based, so if you, for example, required employees to actually quit, then you've become a health contingent program. And Brian will talk more about that in the next couple slides.
Thanks, John. So our next type of wellness program under HIPAA are what are called health contingent wellness programs. And these types of programs require an individual to satisfy a standard that relates to a health factor for them to be able to obtain a reward, or means that the individual has to undertake more than someone who is similarly situated based on that individual's health factor for that person to get the same reward. And as we previously mentioned, there's two subcategories. There are activity only and outcome based. And so we're going to discuss each one as we go through this. So an activity only wellness program requires an individual to perform or complete an activity that is related to a health factor in order to obtain a reward, but it does not require an individual to attain or maintain a specific health outcome. And we talk about health factors. I think it's important that we define that. So a health factor under HIPAA means like the manifestation of a disease. It could be an illness, a sickness, things like that. So, if we're requiring someone in an activity only wellness program, for example, to complete a number, let's say they have to complete 50,000 steps per month to earn the reward. Obviously that relates to a health factor because some individuals may not be able, because of a medical condition or disability, to be able to walk that many number of steps. And so that's why it's tied to a health factor, because someone might have a medical condition that prevents them from undertaking the activity that is the subject of the wellness program. So another example for an activity-only wellness program would be a program that offers a reward based on changing someone's diet. So reducing the amount of fat in a diet or reducing salt consumption, something like that would be considered an activity-only wellness program. So under HIPAA, there are 5 primary requirements for activity-only wellness programs. And these are obviously just hitting the high notes of the regulatory requirements. Unfortunately, these get pretty kind of deep in the weeds, but for this purpose, we want to highlight the 5 major areas of compliance concern when we're thinking about designing an activity-only wellness program. So our first requirement is that you have to provide the opportunity to qualify for the full reward at least once per year. That one's pretty straightforward. The second is that HIPAA limits the amount of rewards that are available through an activity-only wellness program. And when we're calculating the reward, we have to take into account not just this particular activity-only wellness program that we're talking about, but any other health contingent wellness programs that an employer might have, because it's not unusual, especially for larger employers, to have maybe different types of wellness programs. And so when we're looking at the reward limitations, we need to think about what are all the programs involved, where are they classified in our HIPAA chart to make sure we're taking into account all the possible rewards. So the general rule is that the reward cannot exceed 30% of the cost of employee-only coverage. And if we are designing our wellness program to have a tobacco component, the HIPAA regulations allow us to have a higher percentage of 20% related to that tobacco cessation. The rules also allow the reward to be determined based on like the family-only coverage, for example, if the employee and spouse are allowed to participate in the wellness program. We didn't include that in the slides because, again, that gets a little more into the weeds on calculating reward limitations based on plan design, but there are rules that allow that tell us how to calculate what the reward limitations are based on who is actually participating in the program and the coverage that they're enrolled in under the health plan. Our next requirement is that the wellness program has to be reasonably designed. And these are facts and circumstances tests under the HIPAA regulations, which means that they're much more qualitative than quantitative in nature. So to be reasonably designed, that means that the program has to have a reasonable chance of improving the health of a participating individual. It can't be overly burdensome. It can't be, a subtle or subterfuge way for discriminating against someone based on his or her health factor. And the method chosen to promote health or prevent disease must not be highly suspect in that approach. And so it's really important that when we're thinking about this, we can't, be overly burdensome. For example, that one comes into play quite a bit. Some employers in the past have wanted some really onerous requirements that someone would have had to do 2 hours worth of activities every single day to get a reward. Well, obviously that's going to be overly burdensome and not allowed under these regulations. So this is more of a facts and circumstances test where we have to really dive in and say, does this seem essentially reasonable based on what we're trying to accomplish? The next requirement is that the activity-only wellness program has to be uniformly available for the reward and has to provide a reasonable alternative standard. So the reasonable alternative standard, as its name implies, is another way for an individual to attain the same reward. And that the reasonable alternative standard has to be provided if it is unreasonably difficult due to a medical condition or it is medically unadvisable for the participant to undertake the activity that is part of the wellness program. So for example, let's say someone has a broken leg and our wellness program is, walking 50,000 steps a month. Well, obviously someone with a broken leg who is in a cast is going to have a very difficult time walking 50,000 steps a month. And so in that case, we'd have to provide them a reasonable alternative standard to allow them to achieve the full reward that someone who doesn't have a broken leg is able to achieve under the program. Then finally, we have to provide a notice of the availability of the reasonable alternative standard. And the rule here is not 100% clear. So the rule says that you have to include this notice in all plan materials that describe the terms of the program. You have to, when you're describing the terms of the program, you have to provide this notice of reasonable alternative standard. But if you're merely mentioning the program, then you don't have to provide this notice. And so it's not always easy to tell when we're, just mentioning the wellness program versus describing the terms of the wellness program. So we typically recommend just including the notice of the reasonable alternative standard availability, because the model notice that's in the regulations is, short couple sentences. So it's really easy to include in basically any materials that would describe the wellness program. And with that, I'll turn it over to John to talk about our outcome-based wellness programs.
Thanks, Brian. So with an activity-only wellness program, you have to complete an activity. With an outcome-based wellness program, you have to obtain a particular outcome. These are fortunately named to be pretty clear. So that you have to obtain a specific health outcome in order to obtain a reward, such as, we give some examples here, reducing your premium if you are able to get your body mass index below 30, or reduce your total cholesterol below 200. And the issue with these is that when you look at these requirements under HIPAA, and most of what Brian said that relate to activity and wellness programs apply here. And if you look just at the same 5 requirements, they look pretty similar, right? That there's an opportunity to qualify for rewards. There's reward limitations that are largely the same. You have to be reasonably designed. You have to have a uniform availability of a reasonable alternative standard and provide notice of that. So it's easy to think that, there's no real difference between outcome-based programs and activity-based programs, but there are. For example, with an activity-only program, a reasonable alternative standard has to be offered to any person for whom it's unreasonably difficult due to a medical condition or medically inadvisable, as Brian said. But with outcome-based programs, you have to offer a reasonable alternative standard to anyone who doesn't meet the initial standard already based on their measurement, testing, and screening. And if the reasonable alternative standard is itself another outcome-based standard, it can't be a requirement to simply meet a different level of the same standard without offering them additional time to comply that takes into account their circumstances. So even though the rules look very similar, there are technical differences between outcome-based programs and activity-based programs. So that was one thing we wanted to highlight from a compliance perspective. And with that, I'll turn it back over to Brian to talk about wellness program regulations and some litigation that has happened in that space.
Thanks, John. So now we're going to switch from the HIPAA rules, which are governed by the U.S. Department of Health and Human Services and enforced by the Office for Civil Rights, that is part of HHS. And we're going to move over to our ADA and GINA requirements, which are governed by a different set of regulations in a different agency, the Equal Employment Opportunity Commission, or the EEOC. And so there's similar requirements, but again, we're dealing with 2 different laws that are much different than HIPAA in some respects. And so we have a different set of regulatory requirements we need to think about depending on how our wellness program is designed. And that's one thing I always like to say, is that there's no such thing as quote unquote a wellness program. Every wellness program is unique. Every wellness program is different. And so it's really important that even if a wellness program looks like something that you've seen or designed before, it probably has some nuances that require it to be really vetted under all these different regulations to make sure it's being offered in a compliant manner. So we're going to take a little history tour as we go through how we arrived where we're at right now in terms of wellness program compliance under the ADA and GINA. So let's rewind back to 2016. In 2016, the EEOC issued new wellness program regulations under both ADA and GINA. And those regulations became effective for the first day, the first plan year that began on or after January 1st, 2017. And those regulations are designed, as we'll talk about a little bit, to make sure that the wellness programs aren't violating the ADA, because there's a lot of concern that a wellness program that's asking like disability related inquiries, for example, might end up discriminating against people with disabilities. And so the EEOC issued regulations to help address that concern. One of the important things that the regulations that were issued in May 2016 did was provide a cap on the amount of rewards that wellness programs could provide under both ADA and GINA and still be considered compliant and voluntary under both of those laws. So under the ADA, for example, the EEOC capped the amount of wellness program rewards or penalties at 30% of the cost of total only employee only coverage if that program made a disability related inquiry or medical exam. And again, it's a little more detailed depending on how the plan is designed, how we calculate that cost and which type of coverage, employee only versus family coverage we do, but for our purposes, we'll just use the simpler employee only coverage. So EEOC provided out that rate, and as part of the rulemaking, it essentially borrowed that 30% limit from the HIPAA regulations. And that created a problem for the EEOC. So later in 2017, the AARP sued the EEOC, challenging the creation of the wellness program regulations. The AARP essentially argued and won by saying that the EEOC, through the rulemaking process, did not properly vet the 30% limitation for wellness program rewards to make sure that that was also considered voluntary under the regulatory scheme that's contemplated by the ADA. The EEOC essentially argued that the ADA and the purpose of the ADA is different, and the rules under the ADA itself are different than HIPAA. So the EEOC couldn't actually just borrow the reward limitations that were available under HIPAA. It needed to do more work and do a better regulatory explanation through the rulemaking process to justify that 30% limit. So the AARP won that litigation, which meant that the EEOC then revised the wellness program regulations for GINA and the ADA to delete the 30% reward limitation provisions that had been originally published as part of that May 2016 rulemaking. So May 2016, we had specific limits in the federal regulations for wellness programs under the ADA and GINA. And then after the 2017 litigation, that specific part of the regulation got removed, telling us what the rewards could be under ADA or GINA. So then we go along for a couple of years waiting to find out, hey, are we ever going to get new regulations? So at the very beginning then of January 2021, before President Biden took office, the EEOC kind of teased new regulations under the ADA and GINA. So these regulations were never formally published, and under US law, for a regulation to be actually considered a regulation, it has to be published in the Federal Register and go through a whole rulemaking process. Well, these January 2021 quasi-proposed regulations were never formally issued in the Federal Register. They were put up on the EEO's website, and it said, hey, we plan on publishing these regulations. Here's what we're going to propose for wellness programs under the ADA and GINA for the reward limitation specifically. President Biden takes office in late January 2021, and just like every other incoming administration, rescinds all these regulations that haven't been proposed yet, puts them on hold so the new administration can review them and see if it agrees with the approach that the regulatory agencies are doing. And as we'll talk about in a little bit, this has created a lot of quandaries for designing wellness programs that have to comply with the ADA and GINA, because before 2021, between 2017 and 2021, we didn't have regulations on what the incentive limit could be. These kind of like teased January 2021 regulations would have only really allowed a de minimis incentive, which is much different than what HIPAA allows. These regulations that were pulled back and put on hold and never released. And so we're still in this quandary of what does it mean for a wellness program to be voluntary under the ADA and GINA, and how much can we charge? And so we'll dive into that here in a little bit. So under the ADA, employers are generally prohibited from making disability-related inquiries, requiring medical exams, or discriminating against individuals based on a disability regarding their privileges of employment, which includes things like fringe benefits. There's an exception that allows an employer, as part of a health program, to make medical exams if certain requirements are met. And that's where our wellness program regulations come in. So the ADA regulations are applied to wellness programs that either have a disability-related inquiry or ask an employee to undergo a medical exam. And as you can probably imagine, disability-related inquiries and medical exams have pretty detailed explanations and definitions under the ADA. The EEOC has provided a plethora of detailed guidance on what is and what is not considered a disability-related inquiry, and what is not a medical exam. So there's pretty good guidance that we can point to tell us what those two things mean. So disability-related inquiry is pretty straightforward. If we're asking someone, for example, do you have a disability? That's a disability-related inquiry. A medical exam would be something like a test or a procedure that seeks information about the individual's physical or mental health. So if we're asking someone to do, blood pressure or a biometric exam that involves a blood draw, that's a medical exam. So then we get pulled into our ADA regulations. The ADA has, kind of similar to what we talked about with HIPAA, its own set of requirements that must be complied with for a wellness program to satisfy the ADA's requirements. And we're going to dive into what each of these means a little bit more in detail, but they have to be voluntary, has to be reasonably designed. We may or may not have reward limitations based on our discussion. We have to provide some disclosures, we have to keep information confidential, and we can't force people to sell their information that's protected by the ADA. So let's jump in and talk about what it means to be voluntary. So participation in a wellness program that is subject to the ADA must be voluntary. And if it is, if the wellness program has our disability-related inquiry and or a medical exam, it's considered voluntary if we do not require employees to participate or individuals to participate. We don't deny coverage under our health plan if the individual chooses not to participate in our wellness program. We are not limiting the extent of benefits for employees who do not participate. We are not taking adverse employment actions against them, such as firing them, retaliating them, or otherwise penalizing them as part of their employment practice. And we provide a notice. The regulations tell us the content of the notice. Essentially, it has to be in plain English. So it has to be written in a way that the average person is able to easily understand. We have to describe the types of medical information and the purposes for which it's going to be used. And we have to describe restrictions on the disclosure of medical information and how it is kept confidential. And there's a form or a sample model notice that the EEOC has provided to help us, prepare and distribute this notice that the ADA requires. Next, our program under the ADA has to be reasonably designed. And again, this is going to be more of a facts and circumstances test where we have more qualitative factors than quantitative factors. So the program has to be reasonably designed to promote health and prevent disease, which is similar to what we had under HIPAA. It is not reasonably designed if it does not provide results, follow-up information, or advice designed to improve the health of participating employees. So it's important that if we're doing disability-related inquiries or medical exams, that we're providing that information to the individual so they know what they can do to address the situations that are found through the wellness program. For collecting any information, it has to actually be used to design a program that is going to address the conditions that are identified. And we need to make sure that we're not cost shifting or using the wellness program to shift cost from targeted employees or doing things like that. That would be considered not reasonably designed. So next, then we dive into our favorite topic, which is reward limitations under the ADA. And I say favorite topic because we go back again to our history lesson, where in 2016, we had regulations. They were terrific. They told us what to do, how to calculate reward limitations, and how to apply them to wellness programs that are subject to the ADA. Under those regulations, unlike HIPAA, the 2016 reward limitations applied to both participatory wellness programs and health contingent wellness programs. And as you'll remember, John told us earlier in the presentation that under HIPAA, participatory wellness programs aren't subject to reward limitations, but under the 2016 ADA regulations, we had this difference where they were applied to participatory wellness programs. So that was one of the many complicating factors when those programs or when those regulations were in effect, we had to be aware of and navigate through. So then, as we'll recall, in 2017, we had litigation that challenged those regulations and ultimately resulting in the EEOC removing the specific reward limitations from the regulations. So right now, we're kind of in this quandary of how much reward is too much reward, or how much penalty is too much penalty for a wellness program that is subject to the ADA to be considered voluntary, because that was one of the major issues of why we have limitations on rewards under both HIPAA and particularly the ADA, is we want to make sure individuals aren't being coerced into participating in these programs, because the ADA says participation is to be voluntary, but if the reward or the penalty for participating or not participating is too high, then it's essentially coercion and not considered voluntary. So that's why the reward limitation is so important, is satisfying that voluntary requirement. So under those 2021 kind of sort of floated, maybe going to be proposed regulations that we talked about, they were only going to allow what is referred to as a de minimis incentive under the ADA. And the regulation said that meant a water bottle or a gift card of modest value. And in true typical, regulatory fashion, we're not really sure what a gift card of modest value means. There was a example in those quasi-floated 2021 regulations that never were formally published that said a $50 a month charge. I can't remember if it was a gift card or if it's a premium reduction. $50 was too much. It was considered too high. So that kind of gave a lot of people pause on what is the EEOC thinking and what are they actually going to propose for reward limitations if and when the EEOC gets around to proposing new regulations under the ADA. So obviously this is creating a lot of compliance challenges for wellness programs that are subject to the ADA, because again, we want to make sure our reward isn't too high to cause an ADA problem. There's actually ongoing litigation right now involving the city of Chicago, where the plaintiffs are challenging the reward limitations under the ADA and GINA, saying it's too high, therefore you're not actually providing a voluntary program. So it's going to be interesting to see how that works its way through the courts. Oops, sorry about that. So our next item is that we have to keep information confidential under the ADA. So the ADA has a specific confidentiality requirement that says that any medical condition or history of employee, we have to collect and maintain it on separate forms. It has to be kept in separate medical files, and we have to treat it as a confidential medical record. So this means if we're running a wellness program that is subject to the ADA, we can't put that ADA wellness program information in the same employment file or personnel file. That kind of day-to-day general, employment records may be kept. It needs to be in a separate file, kept safe and separate from employment records. We need to, safeguard and make sure it's being kept confidential and limiting access to it so that we're in compliance with the ADA. And then finally, the ADA says that we can't require as a condition for participating in our wellness program, and we can't condition any rewards on an employee agreeing to sell their medical information, exchanging their medical information, allowing the employer to otherwise disclose their medical information, or requiring the individual to waive their ADA confidentiality protections. I've never seen an employer actually think about wanting to do this. It'd be really unusual, but the regulation is very clear that you can't condition participation in the wellness program or any rewards under the wellness program on any of these items. We have to keep medical information confidential, and we can't ask employees to waive their ADA confidentiality protections. With that, we're about halfway through our program. We're going to take a short, approximately 10-minute break, so people can go, get a cup of coffee, answer emails, whatever. So we'll reconvene in 10 minutes, and when we reconvene, we'll be focusing on our GINA requirements and then diving into tips on having compliant wellness programs going forward. So we'll see everyone in about 10 minutes.
All right, everyone, we'll get started. So GINA, as sort of mentioned at the beginning, stands for the Genetic Information on Discrimination Act. It was signed into law in May of 2008. And in essence, what it does is it prohibits employers from requesting, requiring, or purchasing genetic information. Fortunately, genetic information is also defined. There's 12 or 13 subdivisions in the statute, and the definitions page provides us a definition of this. And genetic information, in essence, is an individual's genetic tests, not just theirs, but their family members, which are not very common. But the third, and this is what tends to cause the most problems, is also the manifestation of disease or disorder, in essence, family medical history. And family members also defined, and it's very broad. So it's not just you or your spouse, parents, siblings, children. It can also include like your aunts and uncles, great-grandparents, great-great-grandparents. So it's on what GINA in essence does is prohibit employers from requesting this stuff and then using the genetic information they get to discriminate on the basis of that, either in healthcare coverage, which is set forth in Title I, or in employment decisions in Title II. So under Title I, group health plans cannot adjust the premium or contribution amounts, request or require a person to undergo a genetic test, or collect genetic information for purposes of underwriting or eligibility for enrollment or things of that nature. Under Title II, the regulations in essence establish an exception to that general prohibition, where you can offer genetic or health services and request genetic information as part of a voluntary wellness program. Now, employers and the wellness program still have to satisfy all of GINA's requirements. The 2016 regulations, the portions of them that were not rescinded, clarify that GINA applies to employees' spouses, but Title II is what allows wellness programs to collect or use in a limited way genetic information in a wellness program. And the requirements list here looks similar to the ADA. And like when we were talking about with activity-based or outcome-based programs, the list looks similar, but there are technical differences and there are additional requirements here. So whereas the ADA, also required it be reasonably designed and voluntary, and we're going to talk in more detail about all 9 of these, GINA also requires there be written authorization to collect the materials. The ADA also has limitations on disclosure, but GINA adds an additional requirement that the information gathered not be individually identifiable. As with the ADA, there's more limitations and prohibitions on the sale or exchange of the information, but GINA then adds to that you can't deny benefits on the basis of the genetic information gathered. And the ADA also has confidentiality provisions, although again, they differ between the ADA and GINA because they're different laws. And most employers, like the vast majority of the questions we get about GINA, are how to design a program that avoids asking for these sorts of things. GINA compliance is very, very challenging, not just in the scope of the requirements as set forth here, but also just in the breadth and the technical requirements of their use and disclosure. So oftentimes when we're asked to help with GINA compliance, it's how to avoid being subject to GINA at all. But if you want to design a program that is compliant with GINA or that you gather genetic information, it has to be reasonably designed. The acquisition of genetic information has to be, and services around that have to be designed to promote health and prevent disease. That makes sense. That's sort of a general wellness plan staple, right? And much as with the ADA, reasonably designed means that it's not going to be overly burdensome. It's not going to be used as a proxy for violating someone's employment or used to discriminate or retaliate against someone for an employment basis. And the chosen method of the disease prevention or their health promotion is not highly suspect. And if you are going to have a program that measures, tests, or screens or collects health-related information that's genetic in nature, you're going to have to provide participants with the results of whatever test you're gathering and provide follow-up information or advice. And you have to use the collected information to design a program that addresses the conditions you're testing for. As far as being voluntary, you cannot require individuals to provide genetic information, and you cannot punish them for refusing or choosing not to provide it. In other words, you can't deny coverage, you can't limit coverage, and you can't take adverse employment action against a person for not providing it or things of that nature. As far as authorization is concerned, it has to be prior, knowing, voluntary, and written. And much as with the ADA, you have to write authorizations and notices and things in a way that is likely to be understood. But in addition, you have to describe what information you're gathering, what genetic information is being sought. You have to describe how you are going to use it, the purposes that you're using it for. And you have to explain the restrictions on the disclosure, who you're disclosing it to, the ways in which you're not permitted to use it, and all of that. So that the person who's signing the authorization has some idea of how the information will be used and protected. As far as the limitations on disclosure are concerned, you can provide individually identifiable genetic information to the individual or to a licensed healthcare professional. In most other instances, it's going to have to be de-identified. You cannot provide genetic information that you gather to managers, supervisors, persons in their direct chain, or anyone else in the workplace, really. So the information gathered already has a sort of limited scope of use and distribution list. As I said before, it can't be individually identifiable. There are instances in which you can use individually identifiable information, but if it's being disclosed to the employer, for example, it has to be in aggregate and de-identified so that the identity of the specific individuals for whom the genetic information is gathered aren't identifiable. And generally speaking, the information that you gather is going to be limited in the services that can be provided. The GM regulation spells out, but usually it's genetic test, counseling, or education. And they provide some additional details in the regulations as to what that means. As Brian mentioned with the ADA, the rewards are limited. It has created a lot of compliance challenges because we don't know much about what kind of, if there are any limits at all to the rewards that can be offered. But in the context of GINA, you can offer inducements for completing a health risk assessment that includes questions on family history or other genetic information. But you're going to have to be very clear that the reward is available, even if the person declines to answer the questions. And you can offer the same inducements to a spouse, and you can offer inducements to an employee whose spouse provides information about their own manifestation of disease or disorder. But what you can't do is offer an inducement in return for the spouse providing their information or information about their children. That's pretty clearly prohibited by the regulations. Much as with the ADA, you can't sell or exchange this data. You can't condition participation or the rewards that you grant based on them agreeing to allow you to sell, exchange, share, or transfer genetic information. And you can't require someone to waive these protections as a condition to participating either. You can't deny benefits on the basis of the genetic information that's gathered, meaning you can't deny eligibility, you can't limit the package of health insurance benefits they're able to elect or that their spouse is able to elect based on their refusal to provide genetic information, which the typical way that's it's requested is health history or disease history, family medical history. And you can't use the information to retaliate against employees. And finally, you have to maintain this information confidentially. You have to maintain genetic information in medical files separate from the personnel files. This is similar to the ABA. Genetic information is in essence treated as a confidential medical record, and you can't disclose the information to anyone or for the purposes except that GINA explicitly permits. So with that, I'm going to turn it back over to Brian to talk about some common wellness program issues, and then we'll talk about how to mitigate this.
Great, thanks, John. So as we've talked about over the last hour or so, there's a number of different ways that employers can run into challenges, we'll call them, when they're offering a wellness program. So we're going to spend a little bit of time looking at some of the issues that we regularly see, and then we'll conclude in a little while with ways to overcome these challenges. So obviously one of the first things that we discussed today was, hey, there's a lot of laws that may or may not apply depending on how the wellness program is designed. So our starting point, the common issue we see is not taking the time, or an employer not determining how their plan is designed, and based on that plan design, which laws apply. That's a really common problem where the employers thought, oh, I'm only subject to HIPAA, but they're doing something that also pulls them into the ADA, for example, and not then taking on the responsibilities for complying with the ADA. So failure to determine which law or laws apply is a very common problem. Another very frequent problem is employers not determining how the wellness program rewards are going to be treated for tax purposes. Some rewards like cash gift cards are includable in an employee's gross income. The IRS is very, very clear in their guidance that if you're providing someone, $500, gift card, that is taxable income from the employer to the employee. So making sure that rewards are being treated properly for tax purposes is another common compliance issue we see. Similarly, it's pretty frequent for employers to not have set everything down that their wellness program is doing in a plan document or a program document. In other words, they say they have a wellness program, it's sprinkled throughout, like a new hire guide and an open enrollment guide and maybe an employee handbook, but there's not a program document that sets forth all the requirements and so forth for the wellness program and what someone has to do to participate and get the rewards. Another common issue we see is the program materials not telling people to look at the actual plan document, or not calculating the limitations on rewards. As we talked about before, HIPAA has very clear requirements on how to calculate what the reward can be, the maximum reward can be for HIPAA purposes. But then depending on how the program is designed, again, we have to think about, okay, what is the limitation under the ADA, which, as we all know, is now kind of a challenge given the lack of, specific percentages or dollar amounts of the regulations. So that's a common program issue is determining the rewards that apply and whether or not they're too large. Failure to provide notice of the reasonable alternative standard or not providing a reasonable alternative standard is another problem that pops up from time to time. Employers forgetting to include the notification language that a reasonable alternative standard is available and how to obtain it. That happens, fairly frequently, and not actually then providing it, is obviously going to be a logical follow-on problem if you're not telling people that they can get a reasonable alternative standard, and they're probably not actually being provided. So that's a common compliance issue. Failure to provide other notices or obtain authorizations, happens from time to time. Well, let's go to the next slide. So related to that is kind of just not having policies and procedures in place to make sure that all the different notices related to wellness programs are being distributed and then collected if an authorization is needed, and not having a process in place to document that notices and authorizations have been distributed and received. We see that pretty regularly. Another big item that we encounter is employers who don't actually negotiate their vendor contracts. So as I mentioned at the beginning of our meeting today, I spend a lot of time negotiating service agreements, not just for wellness programs, but for nearly every type of health and welfare employee benefit plan that hires a third-party administrator, to offer a service or run their program. And so a lot of employers think that when their vendor gives them a contract like a business associate agreement or an administrative services agreement, that they have to sign that they don't have the opportunity to negotiate it. And typically that is not true. Once in a while, there'll be, employers who don't have that many employees who therefore aren't making the vendor a lot of money, where the vendor will say, no, we're not going to negotiate because you're just too small. But a lot of times for employers that have a decent number of size, employees or a good number of employees, you're typically able to negotiate these contracts, and you want to look at these contracts and have them reviewed and negotiated, because whenever a vendor gives you a contract, that contract is written for the vendor's benefit, not for the employer's benefit. So there's a number of provisions both in the business associate agreement and the administrative services agreement that should be given a lot of attention to, things like mitigation requirements, indemnity requirements, limitations of liability, insurance requirements, confidentiality provisions, and a whole host of other items that really ought to be vetted and negotiated. And depending, again, on what the program looks like and the employer involved, you might want to look at performance guarantees and service level guarantees as part of hiring a vendor to run a wellness program. Similarly, employers can run into problems if they're not monitoring their service providers. That's an ERISA fiduciary duty. So if our wellness program is an employee welfare benefit plan under ERISA, we have a duty to monitor the service providers, make sure they're complying with their obligations. And then another kind of related failure that we see is employers not regularly updating or reviewing their wellness program documents or materials every year to account for changes in how the program is being run, changes in rewards, changes in activities that have to be done to get a reward, things like that. So it's really important that those documents be looked at every year. With that, I'll turn it over to John. John's going to give us some common examples that questions that we receive about wellness programs. And again, some of these are based on questions we've received through the UBA help desk, the compliance help desk email box. So again, we want to encourage you, when you have questions, to use the email box so you can get answers to your questions that you may have.
Thanks, Brian. I'd add as well before we start that this entire presentation was somewhat design based as well on the questions that we get in order to provide you guys the answers to questions that we do typically receive. So none of these are exactly questions that we've gotten, but are based on typical questions we get. So one example would be that an employer wants to implement a rewards program for employees where they receive redeemable credits in an employee's store for completing certain wellness activities, such as an annual exam, smoking cessation, using a teledoc instead of a physical physician, that sort of stuff. What are the issues that may come up in something like this? And the answer is that, tying it back to the common issues that Brian was just discussing, there are a lot of different issues. First is identifying which laws apply. Is this a purely participatory program, or is it health contingent? As we discussed earlier, the regulations, the notices, and the requirements are going to differ a lot depending on the type of program that you have. And this is going to have to be explained in a well thought out program document. Depending on how the program is designed and what they have to do to earn a reward, this may only be subject to HIPAA, or it may have ADA and GINA constraints, which are going to affect the limits of the rewards. One thing that typically trips up folks in a wellness plan is the tax implications of the rewards. So, for example, if they complete an activity and get a water bottle, as Brian mentioned earlier. That might be considered de minimis and not reportable. But the IRS has also taken the position that there is no amount of money too small for them to care about. There is no such thing as a de minimis cash reward. So if they're earning, a gift card, that suddenly now is taxable. Also, if the rewards are too large, you may run into the reward limitation problems, or if the prizes or the credits and things they can purchase in the employee store, like, a barbecue grill or something, may be large enough that is also not de minimis and taxable and reportable as well. So this is an area that it sounds simple, but there's a lot of different things to consider when thinking through these problems. Another example question we get relates to how employees and spouses earn rewards. So if you have an outcome-based wellness program and the employees and the spouses earn rewards separately, how does then that work if you shift to a participatory only wellness program? And the answer is that you still have to keep the rewards separate, because reward separation is an anti-discrimination requirement. And that's true under HIPAA, ADA, and all of that. So that the idea being that when a person is required to complete an activity to earn a reward, you have to credit the reward separately, because the person earning the reward is the person that has to receive it. And they aren't penalized because their spouse doesn't fulfill the reward condition, or that the spouse completes it and the employee doesn't. So maintaining separate requirements is part of the fundamental anti-discrimination approach that many of these laws share. So third example, health plans considering adding a program that charges different pre-tax premiums depending on the amount of engagement with wellness programs. This is a structure that's fairly typical. We see a lot that, if they complete a biometric screen, they get a particular amount of a premium reduction. But if they also complete a health risk assessment or an adult wellness exam, that the discounts get larger the more that they engage with the wellness program. Is that something that can be done? And the short answer is yeah. You can generally offer a wellness program that provides premium reduction incentives. And those incentives can be tiered so that more activities means a larger premium reduction. But the complication here is, as always, there are reward limitations. Brian alluded to the fact that the regulations spell out exactly how these rewards have to be calculated. So if you have a smoking cessation component of that, combined with other sorts of wellness, you can run into compliance issues, even if your overall reward is below the 50% threshold. So there's a lot to think about as far as these are concerned. But the bottom line is you can design these programs in an almost unlimited number of ways, but how you design them is going to affect the problems that you run into and the compliance issues you're going to have to address. So with that, I'll turn it back over to Brian to talk about some recommendations that we have for making sure your plan stays compliant, or things you want to think about.
Thanks, John. So a lot of these are going to be very straightforward, but nonetheless are not always the easiest things for employers to remember to do or to implement. So top of mind compliance recommendation would be to make sure that you actually have a wellness program document that spells out how the wellness program is actually designed. So things like eligibility, participation, what rewards are available, what someone has to do to earn the rewards, and that includes all the different items that we've talked about today, depending on which law or laws apply. It's really important that because, wellness program, depending on how it's designed, can be subject to a lot of different laws, that you're designing a wellness program that actually sets forth that it is complying with those laws. And one of the reasons that is important is because there has been quite a bit of litigation, as we've seen and discussed this hour, on wellness programs and whether or not they are satisfying different laws, such as the ADA. Well, if you have a wellness program that clearly sets out in a document what the program is doing, who's eligible, how the program complies with law A, B, and C, that makes it much easier to defend in the case of litigation. So we recommend having a wellness program document. Next is making sure that you know what the rewards that the wellness program provides are, and that those rewards are being properly treated for tax purposes. So making sure you know what the rewards are, that they're being properly treated and reported if necessary for tax purposes. Another, as we talked about, it's pretty common for the reasonable alternative notice not to always be included where it should be included. So going through and updating the different documents that reference or discuss or detail the wellness program, making sure all those materials have the notice, and refer individuals to the appropriate person to request a reasonable alternative standard is pretty important. Another issue we see is employers putting their plans kind of on autopilot and not calculating, okay, our rewards are going to be okay for this year, but then not doing the reward limitations going forward for multiple years. And as we all know, with medical inflation and things like that, what might work for 1 year isn't going to work for a future year. So it's really important from a compliance standpoint to look at the reward limitations every year and make sure they're going to be compliant with HIPAA, assuming that our program is subject to HIPAA, and with the other laws that we've talked about today. And similarly, we should be updating our plan document every year. We also think it's a good idea. Let's go to the next slide, Sean. We also think it's a good idea to establish policies and procedures to make sure that if you're offering a wellness program, that you have a checklist or things like that to make sure that the policies or that the different notices and authorizations, to the extent that they apply, are being prepared and distributed, and having policies, procedures, and checklists to make sure that you're keeping track of that. Because again, in the event of a litigation, that's another way to help defend yourself and say, look, we provide the notice. This is our procedure for making sure the notices are distributed. We did distribute the notice on this date. It was included in materials A, B, C, etc. That's a really good story to be able to tell in case a regulator or a litigator would ask how you complied. As we mentioned before, it's important to review and negotiate vendor contracts if you're hiring a third party to run your wellness program, making sure that those agreements are thoroughly reviewed and, to the extent possible, negotiated. Because, as I mentioned before, vendor contracts tend to be, at least initially, really written more for the vendor's protection than the employer's protection. And so there's things that might not be favorable for the employer once they look at the details. And then we should be, just like in any employee welfare benefit plan, we should be monitoring service providers to make sure that they're following their contracts and their services, and we're documenting that review to make sure we're following good ERISA fiduciary practices.
So I'll add to that one of the reasons it's important to establish the policies and negotiate vendor contracts is because ERISA requires that plans be administered according to their written terms. And that doesn't just mean the plan document, it also means the policies and procedures that are used to operate the plan. And participants are also allowed to ask, usually, for contracts, copies of contracts that underlie and are part of the administration of the plan. So setting forth these policies and procedures is an important part of compliance, and then actually administering the plan in accordance with their terms is an important part of ERISA compliance as well. And the reason I'm adding this is because we're going to turn it over to questions. We've already received several. So one question we received is from Lisa, who asked, who typically drafts the wellness plan program document? And the answer is, you're correct, Lisa, that ultimately the named fiduciary plan sponsors are ultimately responsible for making sure that a wellness program document exists and that it's updated. However, every plan we work with, we're legal counsel for, we typically draft those wellness program documents.
And on that note, if you're hiring a third party to run the wellness program, they might provide you a quote unquote sample or draft document. But again, because there's no such thing as a wellness program, that each one is, individual to the employer, it's a good idea to have legal counsel draft those, because just because the vendor is giving you, a sample document, just like any sample document a vendor gives you, because it has legal implications, it's good to have an experienced employee benefits attorney draft those documents. And as John said, we've done that for a number of our clients.
Yeah, and so another question that we received is whether employers are ultimately responsible for providing a reward, or whether carriers can get involved to provide rewards. And regardless of who's providing the reward, whether there are restrictions on the types of rewards that are offered, this is from Savannah. And the answer to that question is that usually the employer is the one providing the reward because they're the ones providing the funding for the plan. We have seen instances where carriers are providing rewards too, but that tends to be extremely complicated from a tax perspective. I've answered several wellness plan questions through the UBA compliance desk that are, in essence, trying to take pre-tax cafeteria plan contributions and turn them into post-tax money, and those are that's usually not allowed. Are there restrictions on the types of rewards offered? I mean, the answer is that rewards can take a lot of different forms. There are amount restrictions, and there are usually tax implications depending on the type of reward offered. So as Brian mentioned, under the de minimis regulations that were proposed, they said a low dollar gift card or a water bottle. Well, a water bottle probably is not taxable, but a low dollar gift card always is, because it's cash or cash equivalent. So what would you add to that, Brian?
Oh, sure. And another restriction, some employers think about doing like different types of like raffles or things like that in connection with wellness programs, or even in just other contexts where they want to have some kind of raffle type event as part of their wellness program. And employers who do that also need to be careful, because typically state laws govern raffles. And so an employer might not think, they might just think they're doing, kind of something, fun for their employees. But depending on what state they're in, what the state law says, they can get themselves in trouble by running a raffle. So just another thing to keep in mind is that type of activity might be regulated by a state gaming department, or by typically like a state treasurer has regulations relating to raffles. So just another thing to be cautious of is, depending on what the raffle is and how it's being run and who's participating, things like that, making sure it's being done according to state law.
So we're happy to answer additional questions to the extent there are any. We have a few more minutes.
And if there aren't any questions, that is fine too. You can always, if we know we've given you a lot to think about, and unfortunately, this is a pretty detailed, fact-specific area of law, because again, there's no such thing as a wellness program, and there's a lot of items to navigate from a compliance standpoint when we're designing and presenting our wellness program. So if you do think of questions after the program, you can always email the UBA compliance help desk and get some general advice and general thoughts on compliance. And that's part of your membership, so we encourage you to use it.
You can also reach out to Brian or I directly. Our contact information is on the screen here. And we're happy to also answer questions if they occur to you after. Thank you, everybody, for your attention and your questions, and we hope this was useful to you.